Thank you so much for clicking this video. This is Batok with Ola and my name is Mujola Oluwa, and today we want to talk about covenants in restraint of trade. YouTube tells me that less than half of people who watch my videos are actually subscribed to the channel, and I wonder why. Come on, please hit the subscribe button, please subscribe to this channel. It's very important, and turn on the notification bell as well, so that when I drop a new video you will see it. My videos are usually lawyer, layman and law student oriented, and there's feedback on the channel. You can comment, you can send me emails at houseoflivingstones@gmail.com, and you can book a paid consultation with me. You discuss your legal challenges or dilemma, where I will provide a tailored, cut to fit legal solution or solutions to all your challenges. Thank you very much. Please check the description box for links to do this. Today we want to talk about covenants in restraint of trade, because someone left a comment on the video that I did on probationary periods in employment and said that let's talk about covenants in restraint of trade. And so Steven, this video is for you. We want to talk today about covenants in restraint of trade in detail. Don't forget that labor and employment law is an area of specialty for me. I'm passionate about it. It's very important for us to talk about these things from an employee perspective and from an employer perspective. These things are things that we go through and experience daily, and it's important for us to have the proper perspective to it. Covenants in restraint of trade are covenants or clauses in a contract of employment which prohibits the employee from engaging in business, whether on their own or in another employer's employ, same business in the line of business of the current employer, for a period, for life, for a short term, a long term, or for life. So essentially what this means is that if I employ you, maybe I'm a biscuit maker now, I employ you in my service, and then you sign a contract of employment. Now there will be a clause in that contract, or it could be even a separate agreement on it, so a separate document, a separate contract, where I'll be prohibiting you from carrying on that business while you're with me, or when you have left me. You cannot also start a biscuit making business, and you cannot work for another biscuit maker within this number of years. Usually they put 6 months, 2 years, or what have you. So it manifests in different ways. It's not just about employing in the business directly. It also means sometimes in some contracts it may mean that you cannot work for people who do similar work or similar business. It will mean that you cannot talk to customers that your current employer has talked to, customers or clients that you have come to know through your current employer. You cannot do business with them after you have left, or while you are still with us, a separate personal business. It could also mean that you sign a training bond, we train you, and so you have to work for us for so number of years, or refund the money that we spent on the training. So if you want to leave before those number of years are completed, then you have to refund the training fee. So it could manifest in different ways, but the common ways are training bonds, NDAs, non-disclosure agreements, trade secret agreements, non-compete agreements, non-solicitation agreements. Don't take our clients, don't compete with us, return our training fee, and generally don't reveal our secrets. So this is what covenant in restraint of trade is. They are also called restrictive covenants or restrictive clauses or restraint of trade clauses, and that's what they mean that I've explained earlier. So covenants in restraint of trade has the underlying rationale of mobility of labor. Labor must be mobile at all times. In economics, we are taught that mobility of labor is the ability for a willing, available, capable labor, that's a worker, to be able to move from one trade to another, or from one employer to another, from one industry to another. It could be geographical mobility from one place to another in the same line of employment, or from one employment to another. But mobility of labor is very important in employment circles, and it's very important as a labor, intending labor, for you to know if there's mobility of labor in the line of work that you're going into. Now this is why we have covenants in restraint of trade, to restrain that mobility, to curtail the excessive freedom that may accompany that mobility. And that would mean that if you say that you want to work for us, fine, we would invest in you, we would train you, we would trust you to work for us. But the things that you have garnered and gathered from us, you cannot use in the employment of another person. And we can trace these covenants in restraint of trade to English law, Nigerian law, Nigerian jurisprudence is largely influenced, if not completely imported from English law. So we often trace some of these very old and age-long principles of law to English law. We can trace it back to England, and for about 30 years in England, covenants in restraint of trade were held to be completely unenforceable because they were contrary to public policy. The judges, the courts will look at them and say that, oh no, we cannot enforce this. It is not good. It does not work, for public policy. And the origin can be traced to Dreyer's case. In Dreyer's case, a London practitioner had entered into a contract with his apprentice, saying that he would forego his debts to him if after his apprenticeship finished or expired, he would not work in the same line of business in that same city for at least 6 months. So after 6 months, he could, do whatever he wanted to do. When this matter came before the court held that it was contrary to public policy and that such a clause in the contract cannot be enforceable. The court even threatened that if the employer had come to court, he would have jailed the employer. The judge said he would have jailed the employer because this kind of covenant is contrary to public policy. So this is the origin of covenants in restraint of trade in English law. And this was the position for about 30 years, about 3 decades. It was held that covenants in restraint of trade are unenforceable because they are contrary to public policy. But as time went on, in another case, the courts began to look at it from a different perspective and began to, create exceptions that, okay, they are generally unenforceable, but if we see this and this, we may be forced to enforce it. And that's what will lead us to another case. That's the case of Mitchell and Reynolds. Please read up on this case. In this case, the judge was able to distinguish between voluntary restrictive covenants, general involuntary restrictive covenants, and particular restrictive covenants. So the court held that general involuntary restrictive covenants are void, but voluntary restrictive covenants, that's covenants in restraint of trade that was voluntarily entered into by both parties, that are particular in nature, they can be enforced. And what does the court mean by being particular in nature? That would mean that in this case, there's an interest that the employer wants to protect by asking the employee to come into this covenant. That interest is a genuine interest. That's the second leg of it. The interest is a reasonable one, and then there's a scope, and then there's a time and a place. So for instance, I'm a biscuit maker, like the example that I gave earlier. If I say that anyone who works in my service can no longer work in the biscuit making industry, for life, that's a general restrictive covenant. It is involuntary because no one would want to enter into it, or they would probably enter into it because they don't have a choice, but it's not something they would agree to ordinarily. It will be unenforceable because the scope is too wide, the time is too wide, the place is too wide. What I've essentially said is that once you work with me, you're doomed. If you leave me, you cannot work anywhere else. So we cannot have that. But if we have something that's particular, say, okay, if you work with me and I show you the secret of my business, or I train you in this way, expend these resources, expose these particular trade secrets to you, then when you leave me for this short period of time, you cannot work in this line of business. You cannot set up a parallel business, or you cannot work for another employer. We can distinguish it such that we would be able to decipher a genuine interest that I'm trying to protect, and there's a time frame, maybe for 6 months or for 1 year or 2 years after. That time would enable me to probably restructure my processes, or strategize on how to get new employees and protect my interests, and it would not incapacitate you for life, because you cannot say that because someone has worked for you before, they cannot work elsewhere again. And we'll see this as we go on. To illustrate this position, let's look at the case of Overland Airways and Captain Raymond Jam. It's a Nigerian case, and what happened in that case was that Captain Raymond Jam was employed by Overland Airways. Then they sponsored him for a training program in aviation, and you know that aviation trainings are costly if you're familiar with them. So he entered into a training bond with them that for 4 years he will continue to work with them, because they have sponsored that training. So before the expiration of those years, Captain Raymond decided that he wanted to move on with his life and repudiate that contract, and then Overland took him to court. The court held that there was a reasonable interest they were trying to protect. You entered into this bond willingly, voluntarily, and they have expended these resources on you in exchange for 4 years of service. So you cannot just wake up and say you want to go and then put them at a total loss. So that is a very vivid way, or a vivid example of how to decipher this a genuine interest that the company is trying to protect, and if there's a time frame, if the scope is not too wide, and if the interest is not contrary, the protection of that interest is not contrary to public policy. So the court enforced the covenant in restraint of trade. You can look at Komoulis and Leventis Motors Nigeria Limited as well, to understand this properly. It's a Supreme Court decision. So the court has decided in different ways in different cases. But the case that we want to discuss in detail in this episode is Irokotv Nigeria Limited versus Michael Ugwu. Irokotv Nigeria Limited and Michael Ugwu. I wrote about this case about 3 years ago. I would leave a link to my article on it in the description box. I want you to read it. I would explain what it says, but I really want you to read it so that you get a good grasp of this. You know that over the world generally, attrition rates are sparking. They are sporadically going higher in across different industries, especially in banking. For instance, I learned that they now have training bonds, and in several other industries they have NDAs, they have non-compete, non-solicitation agreements that you have to sign when you're getting into their employment. So if someone is telling you, I've seen the lawyers say that, oh, these covenants are unenforceable, so go ahead and do you, and just take off whenever you feel like. It doesn't work that way. The court will distinguish each case, and if in your case the court decides or is able to reach a decision that your employer has something to protect and that there's a genuine interest and that it's not contrary to public policy, you might be in a little soup. And if you're an employer, so your employee takes you to court and the court is able to decide in their favor, you also might be in some soup. So why not let's look at Irokotv Nigeria Limited and Michael Ugwu's case together as we try to understand covenants in restraint of trade even better. More importantly, I think we must always call to mind the rationale behind principles of law. It's a common law principle, fine. What it says is that an employee is prohibited from doing the same business as the employer, whether in the employer's employ or when he or she has left the employer's employ. Now, the court will protect mobility of labor as well. So how do we just juxtapose these competing interests? How do we balance them? So if you're an employee, for instance, and you're going into someone's employment, you should also go in with your conscience, and you should think, what is the best for me and what is the best for my employer, and how can I balance this competing interests? Same goes for an employer. You must not just think of how you can take and take and take from your employee, and you must not just think of how you can take and take and take from your employer. Employment contracts are give and take contracts. You give value, they give you value in return, the value that is useful to you, and you churn out the value that is useful to them. So you must always look at it, balance these things together. In Iroko and Michael Ugwu, let's call it that. In that case, what happened was that Michael Ugwu was living abroad. He wasn't living in Nigeria, he was living in the United Kingdom. And Irokotv recruited him to come and work for them as an executive. He was promoted to an executive when he came anyways. And then they had all these employment agreements that they came into, a salary, what he'll do for the company and all of that. So he came and resumed work. 2 months after he had started working for them, they introduced an NDA into their relationship, that you have to sign this NDA. This NDA essentially was saying that you cannot relate with our clients, people that you've come to know through us, you cannot relate with them, you cannot set up a parallel businesses. Irokotv, if you're familiar with Irokotv, you know that they distribute films, Nigerian local content in the entertainment industry, music, films, and what have you. That's basically what they're into. So they were saying in the NDA, in the non-disclosure agreement, that you cannot relate with customers that you have come to know by virtue of working for us. You cannot also set up parallel businesses that are in the same line while you're working for us. You cannot do this, you cannot do that, several other things. Now, after working for them for about 2 years, they sacked him. Technically, I say technically because they had a fallout, so they prevented him from accessing his office and from doing, all the things he used to do for them anymore, from carrying out his duties. And then they did not pay his last month's salary before he left them. Then they were asking the court to enforce the non-disclosure agreement that he signed with them. Now, let me read out what the non-disclosure agreement says to you. They particularly pleaded clauses 3E and 7. And 3E says that the employee shall not take up job with any of the employer's clients, vendors, and partners without the written permission of the management of the employer. Yes, that's 3E. And then 7 says that the employee agrees that if his employment with the employer terminates for any reason, the employee shall not for a period of 2 years from the date of termination have any business dealings whatsoever, either directly or indirectly or through corporate entities or associates, with any customer or client of the employer or his subsidiaries, or any person or firm which has contacted or been contacted by the employer, a potential customer or client of the employer, and the employer shall keep in strictest confidence both during the period of employment or thereafter, not disclose or divulge to any person, firm, or corporation, or used directly or indirectly for my own benefit, seek of others, any information which in good faith and good conscience ought to be treated as confidential information, including without limitation, information relating to the software developed by the employer, information as to sources of and arrangements for the employer, dealings with movie producers, actors, actresses, artists, etc., customer or contact lists, or any other confidential information. So Irokotv was asking the court to enforce this against Michael Ugwu because he had actually created 2 platforms that were doing similar things to what Irokotv was doing. He had created Africa Agent Limited and Freemade Digital. Both of them were music streaming platforms and music distribution platforms, and they were doing similar things to what Irokotv was doing. So this was already in contravention of what is signed with them, and this was while he was still in their employment, and this would probably inform why they fired him the way they did, by preventing him from gaining access to their office, the office he was using while with them, and all the other things that he used to use for his job while he was with them, unceremonious way of excusing him out of their business. Probably they found out, they were angry, irate, and then they decided to do that. But this is where we're going. They were asking for several things. That is Irokotv that went to court. But importantly, what they asked for, which is related to what we're talking about, is for the enforcement of the clauses that I've read to you, which they claim that Michael Ugwu had contravened. Now, in enforcing this contract, the court did not just say, these are restrictive covenants, we don't enforce it, generally go away. No. Remember I told you that after about 30 years, the court had a rethink in England, and of course, jurisdictions that adopted the English law, they also follow this route to say that let us look at each on a case-by-case basis. Now, what are the things we look for? The first is there a legitimate interest capable of being protected? Is there a genuine interest? Like I said, a genuine interest, a legitimate interest capable of being protected. In this case, the court held that there was no interest. Remember that in Captain Raymond's case, the court held that there was an interest to be protected because the company, the Airways, had already expended a humongous sum in training you. So you cannot just abscond without paying them back their money or working for them for the number of years that you signed up for. It will be their loss. In the case of Irokotv, the court held that there was no interest because the court was able to decipher from the evidence that both parties tendered that Michael Ugwu came into the company at his very young stage, and he was the one that helped them to set up a lot of things, put a lot of things, a lot of structure even into the company. So it wasn't as if maybe there was an employee policy or there was an employee modus operandi, like maybe a system of things, that this is how we do things, this is what you must not do, this is what you should do, these are our trade secrets, these are our core, selling points that we do not expose to outsiders. These are the things that you have now come in contact with, the things that you are now you now have in confidence, which you cannot reveal to another person, why you cannot just leave and set up another business or work for another person in this same line of work. So the court held that these things were not there. Let me read what the court said to you. The court held that the claimant had failed to prove that they were indeed secrets it sought to protect, as its pleadings did not reveal any written policy, procedures, or regulation for its employees, which were communicated to the defendant at any point in time. So on leg 1, the court held that Michael Ugwu won. Now on leg 2, public policy. The court examined the NDA if it was contrary to public policy or not, and the court found that it was actually contrary to public policy. Why? Because there was no NDA at the time of signing the contract. Michael Ugwu had already accepted to come work for Irokotv, left his abode in the United Kingdom, relocated to Nigeria. So the court held that he had changed his circumstances as per his residence, his financial situation, before Irokotv introduced an NDA into their contract. So the court held that that was contrary to public policy. It was as if they were shocking him, like he had no idea that this was going to come up. He just recruited him, come work for us, we'll pay you this and that, discussed generally, and then he took off, he came to Nigeria, started working for you, and he was now at your mercy. Then you now introduced a non-disclosure agreement, which you are now seeking to enforce. So the court held that on that ground it was contrary to public policy. This is why I said that it will differ on a case-to-case basis, because if in your own case you signed the NDA at the point of entry, you knew what you were going into, that would be a voluntary and particular, most likely, interest that the company or the employer is trying to protect. So it might not be contrary to public policy. But in Michael Ugwu's case, the court held that on the ground of public policy, the NDA was contrary, and so it could not be enforced. And now the third ground is the ground or the test of reasonableness. The court looked at the content of the NDA. Is it reasonable? The court held that, having held that initially there was no legitimate interest, the court held that since it did not find any legitimate interest sought to be protected by Irokotv, then it was not reasonable. That is, the interest they sought to protect was not legitimate, and so it would not be reasonable to try to enforce the NDA. So the court held that the only reasonable thing now, the balance of reasonableness is in between both parties. So the court looked at it that, okay, in the case of Irokotv, you have no interest that you are protecting. It will not be reasonable for us to even enforce the NDA. In the case of Michael Ugwu, the reasonable thing is for him to remain employable and to be able to live his life and earn a living now that you have taken his means of income from him and he has left your company. So we cannot restrict him by your NDA and continue to leave him at your mercy. So the court held that it was not reasonable to enforce the NDA. Now the court likened the right to earn a living to right to life, that if a man is earning a living, then he can preserve his life, he can live very well. So the court held that it will be contrary to public policy and it will be unreasonable, to enforce the NDA against Michael Ugwu, so as to prevent him or deprive him of earning a living. So all these three tests were in his favor, and so the NDA was not enforceable. Of course, there are other things that came up in that case, but I just want us to pick out that issue of restrictive covenants. So this is how to understand restrictive covenants. If you are being employed by a commercial bank, for instance, and they have asked you, you have signed a training bond that they're going to train you, maybe they will send you for your master's program or for an MBA, and in return you work for them for 6 years or refund your MBA fees. And now it's time for you to leave. Maybe you've gotten the MBA, you're now very valuable, you want to move on. The right thing would be for you to just refund the MBA fees or work for them for that number of years. Now, if the case comes to court, the court will look at several things. Yes, they cannot tie you down. We cannot force an unwilling employee on a willing employer, and vice versa. But will it be good for the court to say go away with all the MBA fees? You know how expensive MBA fees are. They have invested in you, they should reap. If they are not reaping, then restore them to status quo ante bellum and let the party go their way. So generally, covenants in restraint of trade are not enforceable, but the court will look at each on a case-by-case basis and perform 3 tests, generally, the test of reasonableness. Is it contrary to public policy or not? Is there a legitimate and a genuine interest? And some other tests as to the scope, of that interest. Is it for a certain term? What is it covering this a geographical location that, okay, you cannot work for a biscuit maker in Nigeria, but you can work for a biscuit maker in the United Kingdom or in the United States of America. The court will look at all those things before it arrives at a decision in each case. So this is how to understand covenants in restraint of trade. If you have a question, leave it in the comment section. If you need a proper consultation to understand your own situation, you can book a paid consultation with me. The link to book is in the description box. And I want you to read my article on Irokotv and Ugwu to get a better grasp of this. Steven, thank you for leading us this way on the channel. I will see you in my very next video, everyone. Toodles.